So I guess it's about time we proceed. So tonight, thanks again for joining tonight's tutorial. We're going to be covering the Week 8 topic on construction of terms. And so for tonight, well, before we start talking about this specific topic, I wonder if any of you might have a question which you'd like to take up before we proceed with the tutorial for tonight. Would anyone have any question there? And if you happen to have a question, you can either use your mic or use the chat box. None? Okay. Well, if something crops up in the course of the tutorial, just feel free to say something about it. Okay, we have a question from Sophie, online quiz 2. Could you give us some tips? Well, in terms of the format of the answers, it's mainly going to be the same, similar to the one that you had in the first online quiz. Now, the one thing you have to remember is that the second quiz, I think, is worth 10 marks of the final grade. So there is a bigger weight as far as the second online quiz is concerned. And what it also means is that there will be more problem-based questions instead of a lot of it being based on just theory. A lot of it will be problem-based. And so although the answers will still be based on a multiple choice, you would still need to really analyze the case problems that I have prepared when you answer the second online quiz. Now, beyond that, the other thing is, in terms of the questions that I will be asking in the second online quiz, a lot of them will build on the tutorial questions that we've had. So take close note of the tutorial questions, because the kind of questions I'll be asking in the second online quiz will be patterned on the tutorial questions that we've had. So which means, therefore, that a lot of the principles will become quite familiar to you, assuming that you actually join the tutorial the tutorial discussions, or make sure to listen in on the recordings. So, which means, therefore, that it's unlikely for you to come across problems that are quite unfamiliar, because what I'm hoping to do is really for you to build on what we've already covered in the tutorial discussions that we've had, which should make it quite easier for you to answer the problem-based questions, even if the choices might be based on a multiple choice scheme. Any other questions that you might have? None? Okay. So we could probably proceed. So for tonight, we will be discussing, as I said, the topic on construction of terms. And after completing this topic, you should have a basic understanding of the process of construing a contract, and particularly the primacy of a clear express meaning where one exists, the construction of termination clauses. I actually saw Heidi smiling, I'm not sure for what reason, but I got the sense that when somebody just smiles like that, like Heidi did, it usually means that it kind of demonstrates shows someone who's probably in love. I get that sometimes, Heidi, as well. So yeah, I'm beginning to get that myself. So, and I don't know if I'm correct, but yeah, it's a good thing, despite my age. Okay. So the other thing is, you should have a basic understanding of the process of construing a contract, particularly the construction of termination clauses, the construction and operation of force majeure clauses, the construction and operation of exclusion clauses, and the concept of Contra Proferentum and its particular application in relation to exclusion clauses. So let's begin by dealing with the tutorial question for tonight. Can I have someone read the tutorial question for us? Can I get a volunteer? Someone? You're going to have to press the mic button there somewhere if someone is willing to read the tutorial question for us.
Yeah, I'll do it, Manjo.
Will that be Peter?
Yep.
Okay, thank you, Peter. Go ahead, please.
Michael is going to Belgium on a 3-week holiday to study and eat Belgian chocolate. While he is away, he has asked Libby to house sit. Libby has happily agreed, as Michael has both Foxtel and an espresso machine, neither of which he can afford. Michael and Libby trust one another, but to be on the safe side, they've concluded a written agreement about the house sitting. You may assume that all of the elements of the contract formation were properly met. The contract included A clause in which Libby agreed to water the plants every day and to be liable for any plants which died while she was house sitting. B, a clause in which Libby agreed to ensure the mailbox was cleared daily. C, a clause in which Michael agreed that Libby would not be liable for any damages caused to the house as a result of electrical faults. D, a clause under which either party could terminate the agreement by email with 24 hours notice. Michael then departed on his trip and Libby moved in. She watered the plants every day but did not realise she was overwatering one plant, which only required water weekly. The plant died and she emailed Michael to tell him, but said she did not wish to be liable because he had asked her to water the plant every day. Michael responded that she had agreed to be liable if any plants died, so he wanted her to replace the plant.
Go on, please, Peter.
Upset at this demand, Libby cleared the mailbox daily by placing the mail directly in the wheelie bin. One of the mail items included a job offer for Michael. He subsequently missed out on the job. The following Friday night, she arranged for a dozen friends to come over for a girls' night. In the course of the evening, a paid entertainer visited for an hour and connected a stereo, a smoke machine and some disco lights to create the right atmosphere for his performance. Unfortunately, these items overloaded the electrical system and caused a fire, which quickly took hold and burnt the house down. Libby immediately notified Michael and terminated the contract, as the house was no longer habitable. Michael, of course, was not amused. He demanded that Libby pay the excess on his insurance claims, a total of $8,500, including both the house insurance and the contents insurance claims. Libby, however, pointed to the contract and reminded Michael she was specifically not responsible for the damage caused by electrical faults. She refused to pay. Michael has come to you for legal advice. Advise Michael, A, whether Libby is obliged to replace the plant which died from overwatering. B, whether Libby has breached the contract by putting the mail in the wheelie bin. C, whether Libby's termination of the contract is effective. And D, whether Libby can rely on the exclusion clause.
Thank you, Peter. You make for a good storyteller.
Thank you.
Read a story for me to my daughter. Okay, thanks, Peter. So let's begin by dealing with the first question: whether Libby is obliged to replace the plant which died from overwatering. So if you could, I'd like to give you a minute to post your answers to the question in the chat box So the question is whether Libby is obliged to replace the plant which died from overwatering. So I'm going to post the answer of Martin on the screen to enable those who will be watching the recording to know what's actually being posted in the chat box. Okay. And how about the others? So from Sophie, no. So from Martin, it's a yes, I think. So from Peter, the clear words of the, so Libby must pay. From Luke, must pay as well. So the one who said no, that would be Sophie. Yes, from Michael. Okay. Have we gotten the answers from everyone? How about Heidi? Heidi, do you happen to have an answer there? Oh yeah, the answer. Okay. So from Heidi, it's also a yes. 6:15. Okay. Okay. So the only one who says no, meaning the one who says that Libby has no liability, is Sophie. And then I'm just going to put some other another answer that was proffered by Martin. I'm just going to put it on the screen as well. Now, it's essentially just Sophie who says that Libby isn't liable, whereas the rest of the class, or the cohort now, are saying that Libby should be liable. Sophie, do you think you might be able to explain to us your answer? Sophie, if you could. Sophie, do you think you can try to explain your answer? I'm not getting a response from Sophie. Privately from Sophie. Hold on. There you go. So her answer is, yep. So according to Sophie, she did the daily watering because that was according to the contract. So if that is what is in the contract, why would the rest of you suggest that Libby is obliged to replace the plant? The contract, if you notice, clearly says that, what's that? There. So the contract says, so this is the stipulation in their contract, in which Libby agreed to water plants every day and to be liable for any plants which died while she was house sitting. Okay. So, what do you think? Martin?
Yes, she was obliged to water the plants, but she also agreed that she'd be responsible for any plants that died. There was nothing to limit that. It's simply, if they die, you replace them. And it seems clear and unambiguous. So yes, she is liable for replacing them.
Okay. Comments?
I would agree with Martin on that fact.
Yes.
It doesn't actually, even though Michael has said that her requirement is to keep the plants alive, it doesn't actually state that she needs to keep the plants alive. It just says that she's going to water the plants every day and she's accepting liability for any that will actually die.
Okay. But part of the provision clearly says that she is meant to be watering the plants every day. And what the effect seems to be that by complying with her promise under the contract, the plant died. And so therefore she becomes liable. So she's caught in a situation where if she does not comply with the contract by watering the plants every day, she is in breach of the contract. On the other hand, by complying with her promise or her undertaking under the contract, the consequence has been that the plants died. And therefore she now seems to have become subject to a liability. Does that make sense to you? Can you see the problem there? So she complied with her bargain under the contract, and as a consequence of which, the plants died. On the other hand, if she did not water the plants, she would have been in breach of the contract. Okay. Sophie, what do you think? So much of the chatter seems here to indicate that Libby should still be liable for the plants which died from overwatering. Sophie? Yep. So from Sophie, it's a yes. What does it mean, Sophie? Are you changing your mind or? Okay, so we have a statement here from Martin. I'm just going to post it there. But still, so from Sophie, she did, but still, I'm not sure I recognize the word there, Sophie. Would that be correctly printed there? R-A-D-L-E. Ah, okay. So, but she would still be liable. Okay. Okay. So, can somebody use the mic there to give an explanation as to why Libby might or might not be obliged to replace the plant? Can somebody use the mic?
Do you want an argument as to why she's not liable? Is that what you're asking for?
Just to summarize the answer, whether either way, whether Libby is liable or not to replace the plant.
She's liable. A plain construction of the clause. It seems fairly clear and unambiguous. She has to water them. She doesn't, or whether she does or doesn't. If they die, she's liable. So therefore, she's liable.
Okay, thank you, Martin. So the answer is as stated by the rest of the class is really that Libby is liable to replace the plant, because we only apply the rules of construction of contracts is if there's some ambiguity in the contractual promise of one of the parties. In this case, it's quite clear. There is nothing ambiguous in the statement that Libby has undertaken to be liable for any plants which would die while she was house sitting. And because the undertaking of Libby is express and it is unambiguous, then there is no occasion to apply rules of contract construction. So there is no occasion here for us to try to construct the meaning of the contract, because the undertaking of Libby is quite clear and unambiguous. And because Libby has in fact made the undertaking and obliged herself to replace the plant if they died while she was house sitting, and because the plants in fact died, then in that case Libby is obliged to replace the plant. Okay, Although, as you notice, she does, Libby does put herself in a difficult situation because, on the one hand, she had to comply with her obligation, part of her obligation of the contract, to water the plant each day. But as a consequence, that seemed to have killed the plant. But again, that would have been an excuse that wouldn't have been valid for her to escape her legal obligation under the contract. And I'm happy. Okay, hold on. Let's see. Okay. Any questions in relation to the first problem that we have? So that should be good. Now let's proceed with the second one. So the undertaking of Libby was that she agreed to ensure the mailbox was cleared daily. So there is a clause in which Libby agreed to ensure that the mailbox was cleared daily. Now the question is whether Libby has breached the contract by putting the mail in the wheelie bin. Can I ask you to post your answers in the chat box as well? So whether Libby has breached the contract, so the answer so far is that she has. Okay, so hold on. So these are the answers that have been posted in the chat box. Now, if you're given a problem such as this, what is the first thing that you need to do? So if you have a case problem such as this, what is the first thing that you need to do? So in other words, if you're dealt with a problem question where you're supposed to determine whether or not Libby has breached the contract, what is the first thing that you need to determine? Okay, so one would be that from loop established is if there is a valid contract, that's one. And we assume that there is a valid contract because we stated there that somewhere there, isn't it? That you assume that there, all of the elements of contract formation are properly met. So you make that assumption. So we assume that there is a valid contract, but what else? So from Peter, what the contract construes, okay? So the first thing that we need to determine is whether or not you should be applying rules on the construction of contracts. That is the first thing you need to determine. Okay, ad idem possibly yes, but as we said, we assume that there is a valid contract because that's part of the case problem. So before we start determining whether or not Libby has breached the contract, in the context of the case problem that we have here, the first thing that we need to ask ourselves is whether or not there is room for us to apply the rules on construction of contracts. And that can only happen if there is some ambiguity in the terms of the contract. because of the terms of the contract are clear, then there is no occasion for us to apply the rules on the construction of contracts. Now, in this case, we seem to be applying some rules on the construction of contracts. Why is that? Are we saying that there is something that's ambiguous in the terms of the contract? What is ambiguous about this? Is there anything ambiguous in that provision, a clause in which Libby agreed to ensure the mailbox was cleared daily?
It doesn't actually state what she's meant to do with the mail once she's actually cleared out the mailbox.
Okay. So it can be argued that what exactly does it mean when the provision says that the mailbox was cleared daily? That seems to be quite unclear. There is some ambiguity in that wording. What does it mean? What does that provision mean when it says that the mailbox was cleared daily? So that seems to be ambiguous. Does it mean that, so because a literal reading might actually mean that you just have to clear the mailbox. And therefore, if you clear the mailbox, there is no obligation on the part, for example, of Libby to have to safekeep the contents of whatever is in the mailbox. It could actually mean that she could actually be given the opportunity to just throw away whatever is in the mailbox. Because if you have a literal reading of the provision, her only duty under the contract is actually to clear the mailbox. But then again, will this provision actually require the application of certain rules concerning the construction of contracts? So from Michael, no, because so for Martin, a reasonable person would read it and ask, what is she supposed to do with it? And from Michael, there will have to be the reasonable person test. Okay, so that's it. So that's the first thing we need to do. If we're trying to assert, in this case, for example, that Libby has breached the contract, we're actually saying that Libby's having breached the contract depends on whether or not the terms of the contract, when you interpret it, would suggest that it was improper for her to actually throw the letters into the wheelie bin. So therefore, there is some ambiguity in that phrase there, that the mailbox has to be cleared daily. And that will require a construction of that specific provision. And the construction, as we know, depends on the reasonable person test. So a reasonable person put in the situation or in the position of both parties, how exactly would they actually interpret that provision? Now, so we're saying that Libby has breached the contract. What is the basis for saying that? So on the one hand, breached as objectively outside the four-corner rule. Can somebody explain that? Can somebody explain the answer? Why would Libby have breached the contract by putting the mail in the wheelie box? So assuming we agree that the phrase there, clear the mailbox daily, is quite ambiguous, why would somebody then make the case that Libby has actually breached the contract? On what basis would Libby be liable for a breach of the contract? What is the basis of Libby's liability in that case? So we agree that you need to apply rules of contract construction. But what is the basis for Libby's liability in this case? So what exactly, okay, in this case, so let's go back to that question. What exactly is the rule of contract construction that we should be applying? What is the rule here? So we agree that there is some ambiguity in the phrase, in one of the terms of the contract. But what rule of statutory or contract construction should we apply? How exactly do we attempt to interpret or to construct that provision concerning the clearing of the mailbox? What rule do we apply? The rule of contract construction.
Yes. The four corner rule is about doing something in a reasonable sort of way, an expected way. So if somebody says, clear my mail, you can take it out of the mailbox and put it on the kitchen table. That's what I need.
Peter, I'm having a problem hearing this. Did anyone experience as well a problem with trying to understand what Peter was saying? There was, I think, a technical problem there. I couldn't quite hear what Peter was saying. Okay, can somebody just take the floor? Because Peter has having problems with his connection. So what rule do we apply here?
I think what Peter was going off was the four corners rule.
Yes. And
stating how the person goes, yeah, their liability comes from the contract. So they enter into the contract knowing that they're going to perform the contract in a certain way, and they're relying on that.
Okay. So why would you apply the four corner rule? What exactly does the four corner rule mean here or state here? What exactly is the four corner rule? And then we'll take up what Martin has suggested, that there is a breach of duty to cooperate. We'll take that up in a short while. What exactly is the four corner rule? Why would that be applicable in this scenario?
I think it'd be applicable because it talks about how the conduct of a person has to be permitted or authorized by the contract. So if it's not stated in the contract that it is permissible for a person to do something, then they don't have the right to do it. I'm not sure if that's quite right, but
I think that is the correct rule that you should be applying. Okay, so Martin has stated for us what the four corner rule actually states. So if you undertake to do a thing in a certain way or to keep a thing in a certain place with certain conditions protecting it and have broken the contract by not doing the thing contracted for in the way contracted for or not keeping the article in the place you contracted to keep it, you cannot rely on the conditions which were only intended to protect you. Does that seem to apply to this scenario? Is the four corner rule actually applicable?
I don't think so. I think there's an argument that there might be, but it seems too tenuous because she it's not that she hasn't done what she's supposed to do. She has done what she's supposed to do, but in a way that wasn't probably thought about by the parties.
Okay, so just on Martin, I find it difficult to think that the four corner rule is actually applicable in this case. Because the understanding, if you use the four corner rule, is that there's actually an agreement on what is meant to be done. And as a result of doing that which is meant to be done, you then are able to claim that you don't have any liability. But in this case, there is some ambiguity as to what the obligation actually is. I think the proper case that should be applied here is that case of Australian Broadcasting Commission versus Australasian Performing Right Association, where the High Court said that if a provision is subject to two or more interpretations, that interpretation which appears to be reasonable or which is not capricious should be the one that is adopted. In this case, if you examine, therefore, the provision concerning the need for the mailbox to be cleared daily, a reasonable and a non-capricious construction or interpretation of that provision would suggest that it wasn't within the contemplation of the parties that the items in the mailbox should be thrown into the wheelie bin, right? I mean, a reasonable person in the position of the parties possibly couldn't conclude that clearing the mailbox would actually mean that the items in the mailbox would be thrown in the wheelie bin. That is not something that we would typically do. Okay, so if you apply that rule, therefore, a more reasonable construction would suggest that Libby shouldn't have thrown the mail into the mailbox, into the wheelie bin. Now, let's just address quickly this point by Martin, I think, that there is a duty to cooperate. Is there such a thing as a duty to cooperate? What exactly does that suggest? So is there a common law duty to cooperate, and what exactly does that mean?
I guess I was the one who made the argument, so I probably should support it.
Okay.
I think cooperate is essentially that you it's an implied term by law that will carry out the contract in a way that was intended, as opposed to doing something completely unintended and contrary to the intention of that contract.
Okay. But what exactly does a duty to cooperate mean?
Well, the example given in last week's notes was if I borrow a book from you and I agree to return it, if I leave it in the rain where I know it's going to get damaged, then I've not truly complied with the terms of the contract. Or rather, I'm liable for the damage because it's not within the spirit of the contract. Okay, that's good. So if you'll notice, the duty to cooperate is actually quite similar to the idea as pointed out by the High Court in Australian Broadcasting Commission versus Australasian Performing Right Association, that when there is a contractual provision that seems to be vague and that is susceptible to two or more constructions, then that construction, which is non-capricious and unreasonable, should be that which is to be preferred. And so therefore, in this situation, it would be unlikely for anyone for a reasonable person who is put in the same position as the parties to argue that it was open to that person to actually just throw the mail in the wheelie bin. Okay, so the duty to cooperate is a potential argument that can be raised as a way of trying to construct the meaning of this provision. And the other one would be the clear provision, the clear statement of the High Court in the case that I cited, which requires that in interpreting or constructing a provision that is ambiguous, the approach should be to interpret a provision in such a way that it is not capricious nor unreasonable, nor that would lead to an unjust result. Now, having said that, what exactly do we mean when we say that Libby has breached the contract? Because the effect of this was that Michael was meant to have lost a job opportunity. So if we agree that Libby has breached the contract by putting the mail in the wheelie bin, does it now mean that Libby is actually responsible for any damage that might have been incurred by, by Michael in terms of losing the job opportunity? Would Libby be responsible for any losses to Michael as a result of Michael's failing to get the job?
Was that what breaching of the contract would mean? From Arden, yes. From Sophie, no. How about the others? Yes, from Peter. So Sophie is saying no because they didn't mention it in the contract. So from Luke, Michael could seek damages. From Chris, yes. From Michael, yes. So again, in this case, Sophie is the one who's making the dissent. Everyone else seems to agree that Libby should be liable as well for any losses incurred by Michael as a result of his failure to get the job. Does that make sense to you? To Luke, it makes sense to him. So to Luke, it makes sense that Libby would then be liable for any losses that Michael would incur as a result of his failing to get the job. Does that make sense to the rest of you? Yes, from Chris. Now, how would you compare that to the first situation where you notice where she says here she would be liable for any plants which died while she was house sitting? Was it anywhere in the contract where Libby undertook or promised that she was going to be liable for any damage that would result as a failure of, as a result of her failure, for example, to breach the contract? As a result of her breach of the contract. Her undertaking seems to be she agreed to ensure the mailbox was cleared daily. Was there anything there wherein Libby actually undertook to be liable for any damage that Michael would incur as a result of any breach on the part of Libby in trying to in failing to perform that contractual obligation?
My reasoning for Michael being able to seek damages is mainly because since we've established that the ambiguity in the term where the mailbox has to be cleared daily, and a reasonable person would assume that that doesn't include throwing stuff in the wheelie bin. Due to that, leads into Michael losing his job opportunity because of this failure. So that's how I see that he is able to seek for damages.
Okay, thank you. But the question we need to ask, first of all, is where in the contract did Libby say that she was going to be held responsible or liable for any damage that would result to Michael as a result of Libby breaching the contract? Is it there? It's implied. Okay. So if you say that it is implied, again, we're applying a rule concerning implying certain terms. What exactly is the rule here? Can you imply a term that Libby actually contracted to be liable for any damage that would result to Michael as a result of Libby's breach of any aspect of the contract? Can you imply that actually as a term? On what basis can you imply a term? When exactly do you usually imply a term? Now remember, there are two aspects to the rule on implication of terms. One is an implication of a term according to the law. The second is an implication of a term according to the contemplation of the parties. So in this case, I don't think we can agree that the law will imply a term here. Rather, the possible rule that we can apply is that there might be an implied term. assuming that that is within the contemplation of the parties, do you think that the parties actually intended that Libby would be responsible for any damage that would result to Michael as a result of her improper failure to clear the wheelie bin? The answer is likely no. Okay, so you have to be very careful about adopting the principles on implication of terms. You only imply a term if there is some ambiguity or incompleteness in the contract, and the courts would then try to step in, either one, to see the contract, or two, in order to fill a gap in the contract which should have been within the contemplation of the parties. So in other words, if you have a situation where it couldn't have been within the contemplation of the parties, then the courts will not imply a term. The courts will leave the parties as they are. In this case, I think a reasonable person is likely to conclude, in the position of Libby, that Libby wouldn't have opened herself to the possibility of a liability for any damage that may result to Michael as a result of an improper failure on her part to clear the mails properly. Okay, so yes, it's possible, and we're not talking about what the amount of damages would be, because that's part of contract B. Yes, possibly that Libby has breached the contract, and possibly therefore she is liable to damages, but the damages will likely be only in relation to the value of the lost mail, but not for those other damages that will have to be incurred by Michael as a result of his failure to get the job. And when you think about it, as you will later on see, there will be a question of proximate cause versus remote cause, which we'll learn later on in contract B. And so that it becomes so difficult to argue that the loss of the failure of Michael to get a job, it's difficult to argue that the proximate cause would have been Libby, right? Michael could have Michael could possibly not have gotten a job for a variety of reasons. It could be that there were better applicants. It could be that Michael actually failed to meet the job requirements, and so on. So the remote cause, as we will later on see, might be Libby, but the basic question is, would she have been the proximate cause for the loss of the job opportunity to Michael? The answer is no, as we will later on see. So we agree, yes, Libby has breached the contract and she will be liable for damages, but not to the extent that Libby now becomes liable for any damage to Michael as a result of his failure to get the job. Okay, now moving on, and this should be quick. The other question is whether Libby's termination of the contract is effective. Okay, so the question is whether Libby's termination of the contract is effective. Is a yes, so yes from Sophie. How about the others? Okay, so we agree. Okay, from Luke, it says no. Luke says no, 2 say yes. Peter say yes. Okay, what exactly is the significance here of a termination of the contract? What is the reason for Libby's attempt to terminate the contract? Why did she terminate the contract in the first place? What was her reason for terminating the contract?
She's terminating because she thinks the house is unlivable.
And? Okay.
Yeah, because the house is no longer habitable.
Okay, but the basic legal issue for us is Libby still liable under the contract? So the basic question is, by terminating the contract, does it mean now that Libby is no longer liable for a breach of the contract and would no longer therefore be liable for the damage to the house? So the answer is yes. She can terminate the contract effectively. But the question is, would it mean then that as a result of Libby's termination of the contract, she is no longer liable under the contract? So the answer is she would still be liable. Okay, and we will proceed to the next question now. So, yes, Libby's termination of the contract is effective, but that will not negate the fact that there might have already been a breach of the contract, which would then subject her to liability under the contract. For example, in relation to the house burning down. Okay, so from Martin, she's no longer liable to perform the contract, but that is not the same as not being liable anymore for the breach. So she can terminate the contract, in which case she is no longer liable to perform the other parts of the contract, but it does not negate the fact that liability already attached to Libby as a result of the breach. Which brings us to the final question. There is an exclusion clause in the contract because the contract says, what did it say there? Was there an exclusion clause? Yeah, there is. Okay. So,
sorry, Manjo, sorry to interrupt.
Yeah.
I'm just not quite grasping this, obviously, but just from reading this and in regards to the termination of the contract,
yes.
because it hasn't been stated in a clause or anything like that about how habitable the house has to be. I'm just wondering if she is able to terminate the contract, because there is a express term saying that either party has to give at least 24 hours notice.
The proper answer to that is it actually doesn't matter whether or not the house is habitable or not. The reason why Libby is able to terminate the contract is because it is within her right under the contract. Because the contract says that either party could terminate the agreement by email with 24 hours notice. There is no need for anyone to make a justification for using that clause.
Okay, so they can terminate the email. I think it's the way I was reading it, but the termination has to provide at least 24 hours notice
Yes.
of them leaving the house or terminating the agreement.
Yes. So
effectively, before that 24 hours, to start that 24 hours, they effectively have to email saying they're terminating the contract.
That's right.
And that termination is effective from that email.
Yes.
Okay.
And in this case, therefore, there is even no need for Libby to justify why she is terminating the contract, because it is within her right under the clause. She could terminate the agreement by email. So whether or not she terminates it because she doesn't like to continue with the contract or because the house has burned down, those are actually unimportant, because under the express terms of the contract, either party could terminate the agreement. And that is what Libby actually did. But again, the basic legal issue for us is whether or not Libby will escape legal liability in relation to the house burning down by her act of terminating the contract by email. The answer is no. She will continue to be liable under the contract for the house burning down, subject to her recourse to the exclusion clause. Because remember that there's an exclusion clause there which says that there's a clause in which it says that Michael agreed that Libby would not be liable for any damage caused to the house as a result of electrical faults. So the question is, can Libby rely on this exclusion clause so that even if the house burned down as a result of electrical faults, Libby should not be liable under the contract? So that is the final question that we have to ask. Can I get some answers there? Can Libby rely on the exclusion clause for the purpose of escaping legal liability, at least in relation to the house burning down? Because Libby can make the assertion that under the agreement, she will not be responsible for any damage caused to the house as a result of electrical faults. And we must remember under the facts what caused the house to burn was actually an electrical fault. So clearly, if you look at the clause, Libby shouldn't have any liability because she has, in fact, trying to seek recourse under the exclusion clause, which spares Libby any liability if the house burns as a result of electrical fault, which is what happened in this case. From Michael, it wasn't a fault. Okay, so an argument is made that it wasn't a fault.
I think it's because overloaded is pretty ambiguous. It can be defined as a fault, but realistically, a electrical system in a house should be able to handle a certain capacity of electrical equipment. So then I guess the court has to look at, did she actually go beyond that capacity, hence the overloading, or was it actually a fault of the actual electrical system that wasn't up to standard?
Okay, but the question, so we begin by asking the question, do the facts indicate the need to apply rules of contract construction? Is there actually an occasion for us to try to interpret or construct what the contract means or one of the terms means? Because can't it be argued that the contract is unambiguous? And as a result, because it is unambiguous, it seems to spare Libby from any liability as a result of an electrical fault, then obviously Libby can rely on the exclusion clause. Because remember, we only apply the rules of contract construction if there is an ambiguity in the provisions. Is there actually an ambiguity in the provision? So Peter is shaking his head. Martin is shaking his head. Luke, personally, I think overloaded is an unambiguous term. Is that the issue, Luke? Is that what is at issue here, the word overloading?
I think it would be a cornerstone for an argument, depending on which side you're coming from.
So let's begin with a basic point. Is there an ambiguity in that term, at least of the contract, which would then require us to try to apply rules of contract construction? Is there some ambiguity or an ambiguity in any of the terms? We have to begin with that, because if there is no ambiguity and the term is express, then we shouldn't be applying rules of contract construction. We shouldn't be constructing the contract. So let's begin by that. Begin with that. Is there an ambiguity in the terms of the contract? For Martin, no. So the question is, what exactly is an electrical fault? The answer is that, I think, is an ambiguous phrase. What is an electrical fault? That is ambiguous. That is ambiguous. And because that phrase is ambiguous, or that term is ambiguous, it requires us, therefore, to apply the rules of contract construction. So we need to construct what that term means here. Now, so that's the first thing. That term is ambiguous. And because that term is ambiguous, we need to apply the rules on contract construction. Now, the next question is, what rule do we apply to determine whether or not Libby can rely on the exclusion clause? What principle or rule can we apply? Okay, Martin, contra proferentum. So what exactly does that mean?
It'll be, the clause will be interpreted in such a way as to find a meaning that's acts against the favor of the person who introduced it. Okay.
So, which means, therefore, that if Libby is relying on the on that specific term, following the rule on contra proferentum, the court will interpret or construe that ambiguity against the interest of the party who is asserting it. So in this case, the court will interpret that provision against Libby. Now, so that's the basic thing. In addition, what else? So assuming that the court will most likely, following the Contra Proferentum rule, will most likely construe that clause against the interest of Libby. Would it therefore mean that Libby cannot rely on the exclusion clause? Is that the effect? Libby cannot rely on the exclusion clause? The exclusion clause seems to suggest that she cannot be liable for any damage caused to the house as a result of electrical faults. So couldn't Libby actually rely on that exclusion clause? So from Michael, yes. Okay, so from Martin, it would be construed narrowly. Okay, so it can't be a blanket provision that would allow Libby to escape liability for any form of electrical fault. It has to be construed narrowly this time because of the Contra Proferentum rule. But the other question that needs to be asked is, how then can it be argued that Libby cannot be held liable for the damage to the house when Libby can actually say that the house was burned as a result of an electrical fault? And obviously, if the house burns or is damaged as a result of an electrical fault, Libby is not meant to be held liable for it. So on what basis can an argument be made, or anyone, how can anyone argue that Libby should actually not be able to rely on the exclusion clause? Despite the fact that there is an exclusion clause which clearly provides that Libby cannot be held responsible for any damage to the house as a result of an electrical fault. And I think we can agree that the house burned down as a result of an electrical fault because of an overloading of the electrical system. Aha. So from Martin, we're applying the rule on the four corners. So what exactly, again, is the four corners rule here? Martin, could you explain that?
Essentially, what happened or their conduct went far beyond what was actually intended to be the contract or what the parties were supposed to do.
That's right. So if you apply the four corners rule under the usual contemplation of the parties, if Libby had used the house or lived in the house in the usual way, which was, she's there by herself or she does cooking, she does ironing, then that's fine. That would be within the contemplation of the exclusion clause. But actually, Libby went beyond that in the sense that she had a party and she brought in some equipment as a result of that party. There were disco lights, there was a smoke machine. This event of having a party, having a smoke machine and some disco lights was not within the four corners of the contract. It wasn't within the contemplation of the parties. So the exclusion clause that would have protected Libby would have been valid if the house burned down as a result of an electrical fault in the context of Libby doing just what was within the contemplation of the parties. But in this case, having the smoke machine and the disco lights was not within the four corners of the contract. It went beyond the expectation of the parties. So therefore, in that case, the exclusion clause cannot apply. Okay, any questions? So in this case, the answer is whether Libby can rely on the exclusion clause. The answer is no, because in this case, the exclusion clause only operates on the assumption that the house burned down as a result of an electrical fault that was within the contemplation of the parties, in which case, what would have been within the contemplation of the parties would be an electrical fault as a result of the usual way in which Libby would have habited or stayed in the house. But to have had a party and brought in a smoke machine and disco lights was not within the contemplation of the parties. So as a result, you bring in the four corners rule, in which case it would be difficult for Libby to argue that she can rely on the exclusion clause. Questions? Any questions before we end tonight's session? So we're good. Okay, I've got a class in 5 minutes actually in administrative law. So thank you very much, everyone. And I hope to see you again on Monday next week. Thank you. And I'll see you next week then. Bye.